I'll give y'all my opinion on the live stream tonight, so make sure you got that bell on, right? So basically is this. The DA lays out a couple of cases to support her theory. What is her theory? What she's saying is that since there is essentially 9 defendants who don't have lawyers, right? We can't do the trial in January like we want to. We need the trial done in March, the last week of March, which will give any, how can I say this left way? Any public defender the opportunity to actually defend their clients, right? And this is the thing. I'm not going to tell you what I think, but I'm going to tell you exactly how you should view this. In one instance, you go, well, it don't matter. Y'all arrested everybody. Y'all case should be built, and you wouldn't be wrong. But at the same time, you got to go, hey, thug, how they call you King Slime and you ain't got all your people lawyers? Added, there's still 3 people that's on the run. So in all candor, you about to charge everybody with the same exact stuff and all that, and they'll talk more about it. We'll get more into it with the papers, with the court documents that was filed a couple days ago. But basically is this. We can't take you to trial just yet because y'all don't have y'all lawyers. And in order for a lawyer to adequately defend you, they need about 3 months. And then what's happening is none of them have lawyers. So the lawyers that we seen in the last video when they was saying that we gonna get y'all some lawyers and everything like that, they didn't. Damn Keon Garlington, y'all know who that is. He even kicked his lawyer to the curb. I ain't gonna hold you. That lawyer was pure basura. Real trash. I ain't gonna hold you. But I tell you what, y'all let me know your opinions. I would give you my opinions whether Fani Willis is wrong or right. And we'll get into it. Oh, I'll give you the reason too.
They used to say, words couldn't hurt me. Videos, just my name, they getting thirsty. Go ahead and put him in a hearse seat. It's getting murky, this time I deserve this. I'm ready for whatever war said he been a matador. Scared for the things I'm dreaming for.
In the Superior Court of Fulton County, State of Georgia versus Khalif Adams, ETAL defendants, case number 22-SC-183572, state's motion for continuance. Comes now the State of Georgia by and through the District Attorney, Fani T. Willis, and requests this court grant a continuance of the trial date in the above style case to March 2023, proposed trial date March 27, 2023, such that all defendants may receive effective assistance of counsel. Introduction. The Sixth Amendment right to counsel guarantees a defendant the right to effective assistance of counsel. Black v. State, 264 GA 550 448 1994, citing McMahon v. Richardson, 397 U.S. 759-771 in 14-1970. In the present case, 25 of the 28 defendants are currently in custody. 8 of those defendants in custody still lack counsel. The state moves this court to continuance the trial in the case until March 27, 2023, so that all defendants may obtain counsel and that counsel may be properly prepared for trial. Argument. Unrepresented defendants have a right to effective assistance of counsel. The constitutional guarantee of benefit of counsel to one charged with an offense against the laws of this state means something more than the mere appointment of counsel. Such counsel is entitled to a reasonable time to prepare his defense properly. Black v. State, 349 GA, App 111, 117, 2019, citing Smith v. State, 215 GA, 362, 365, 1959. Spillers v. State, 145 GA, App 809. 1978, where a defendant is forced to proceed to trial with ill-prepared appointed counsel, a court has committed structural error, ID. In the present case, the state now raises concerns that 8 defendants may be forced to trial with ill-prepared appointed counsel, as contemplated in Black. The following in custody defendants still have not been assigned counsel, despite the efforts of the state and the court in setting multiple hearings so counsel may be assigned. Khalif Adams, Cordarius Dorsey, Christian Eppinger, Javon Fleetwood, Demise McCullen, Quinmarvius Nichols, Redelius Ryan, Antonio Sledge. Additionally, counsel for defendant Dame Keon Garlington has filed a motion to withdraw, currently pending before this court. Additionally, defendant Damon Blaylock has recently been assigned counsel, Mr. Sean Hoover. However, Mr. Hoover simultaneously represents defendant Antonio Sumlin. Therefore, the state anticipates filing a motion to address this conflict, which could result in the removal of Mr. Hoover from defendant Blaylock's case. On June 2nd, 2022, the state filed its first motion requesting the court order Georgia Public Defender Council, GPDC, to appoint counsel to 15 unrepresented defendants. The state filed this motion as an emergency motion in court at this time. On July 26, 2022, the state filed its second motion to produce defendants and provide attorneys for unrepresented defendants. 10 of the defendants did not have counsel at this time. The state also moved at this court to require a representative from GPDC to appear to ensure counsel was appointed. At the August 18, 2022 hearings, the state again addressed this issue with the court, and the court indicated it would work on this matter. On August 18, 2022, this court sent an email to representatives from GPDC and copied all counsel and the state, requesting that the then 9 unrepresented and in custody defendants be appointed counsel. At the September 8, 2022, this court produced an unrepresented defendants via Zoom so they could be interviewed by the public defender's office and appointed counsel. As of this date, October 3rd, 2022, none of the 9 defendants have been appointed counsel. The court held a hearing on October 5th, 2022 for the unrepresented defendants, and counsel has still not yet been appointed for those defendants. Trial is currently scheduled for January 9, 2023. The discovery in this case includes over 3 terabytes of data. Further, it is likely that appointed counsel will have other matters pending during the 3 months prior to this trial. The state argues that for counsel to be appointed 3 or less months prior to trial, and while those counsels have other pending matters, does not provide an opportunity for those defendants to have counsel with a reasonable time to prepare their defenses properly. See Black v. State 349 GA App 111 117 2019. The state is cognizant that several defendants, including defendants Williams and Dorsey, have filed speedy trial motions and that this trial is now set for January 9, 2023. However, because those 8 defendants and potentially defendant Garlington, should this court permit counsel's withdrawal, do not yet have counsel roughly 3 months prior to trial. The state believes that future appointed counsel will not have reasonable time with which to properly prepare their defenses. The state thus files this request for continuance to protect those defendants' Sixth Amendment rights. See Black 349 GA App at 117. See also Cannon v. State 136 GA App 479 482 1975. As the concept of the Sixth Amendment right has broadened, courts are required to allow counsel sufficient time to inform themselves fully, to reflect maturely, and to prepare thoroughly in the cases to which they are assigned. U.S. v. Welford, 295, Fed, Approx. 354, 356, 11th Circuit, 2008. The Sixth Amendment right to counsel guarantees a defendant both a fair opportunity to be represented by counsel of his choice and a sufficient time within which to prepare a defense. A continuance to the final week in March will protect the speedy trial rights of those who have asserted those rights, while also ensuring that the additional 8 defendants have properly prepared appointed counsel. B. Defendants should be tried together. Additionally, A continuance is required because all defendants need to be tried together. As addressed at length in the state's responses to several defendants' motions for severance, severance is not proper in this case. Because all 25 defendants currently in custody were alleged to have participated in the same conspiracy, that is the YSL criminal street gang, they should be tried together. See Overton versus State 295 GA App 223, 225 through 36, 2008. Barnett versus State 204 GA App 491, 495, 1992. English versus State 202 GA App 751, 755, 1992. Statefield versus State 256 GA 592, 597, 1987. Robertson versus State 164 GA App 652, 656, 1982. Montgomery versus State 156 GA App 448, 451, 452, 1980. Because each and every defendant is charged with RICO conspiracy, all of the evidence is admissible against every defendant and will remain admissible even if each defendant was tried separately. Overton 295 GA App at 235 through 236. Barnett 204 GA App at 495. Therefore, a joint trial is necessary. Further, the United States Supreme Court has held there is a preference for joint trials of defendants who are indicted together. Joint trials play a vital role in the criminal justice system. Zafaro versus U.S. 506, U.S. 534, 538, citing Richardson versus Marsh 481, U.S. 200, 209, 1987. Public policy demands a joint trial in a case such as this, as the Supreme Court articulated in Richardson versus Marsh. It would impair both the efficiency and fairness of the criminal justice system to require in all cases of joint crimes where incriminating statements exist that prosecutors bring separate proceedings presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. Joint trials generally serve the interests of justice by avoiding inconsistent verdicts and enabling more accurate assessment of relative culpability, advantages which sometimes operate to the defendant's benefit. Even apart from these tactical considerations, joint trials generally serve the interests of justice by avoiding the scandal and inequity of inconsistent verdicts. Richardson versus Marsh 481 U.S. at 210. Reflecting the concerns articulated in Richardson versus Marsh, the state is concerned about the inconvenience and trauma of repeated testimony of witnesses who were the victims of violent gang crimes. As the state has repeatedly shown this court through its previous filed motions and briefings, witness safety is a matter of grave concern in this case. Information about cooperating witnesses served in discovery has been publicly posted and shared on the internet. Multiple witnesses have expressed serious concern about their safety should they decide to testify. Therefore, severance is further discouraged. Additionally, this trial will include, as previously suggested, in the 3 terabytes of data for discovery, hundreds of witnesses and exhibits. There is a strong public policy aim in ensuring efficiency and fairness of the judicial process by trying 25 defendants currently in custody together. Further, as previously articulated, because each defendant is charged with participating in the same RICO conspiracy, the evidence would be the same at both trials, thus favoring the later tried defendants, as the court in Richardson cautioned against. Therefore, a continuance is required to ensure the defendants will be tried together and that counsel for all defendants will be prepared for that joint trial. Conclusion. The state requests this court grant a continuance to the final week of March 2023 to ensure the 8 currently incarcerated unrepresented defendants are able to receive effective assistance of counsel and to thus avoid structural error. All the defendants should be tried. The remaining 3 defendants, Javaris Bradford, Justin Cobb, and Jimmy Winfrey, remain at large. Together, in a continuance to that date, will both protect the rights of all defendants, both the defendants who have requested a speedy trial and those who have not yet been appointed counsel, while also ensuring witnesses are not re-traumatized, judicial efficiency is maintained, and that the trial is ultimately fair and equitable to all defendants. Respectfully submitted this 6th day of October, 2022. Fani T. Willis, District Attorney, Atlanta Judicial Circuit, Georgia Bar Number 223955. Adrian Love, Deputy District Attorney, Atlanta Judicial Circuit, Georgia Bar Number 458998. In the Superior Court of Fulton County, State of Georgia versus Khalif Adams, ET.AL, Defendant, Case Number 22 SC 1835-72. Certificate of Service. I hereby certify that a copy of the foregoing state motion for continuance was served via e-file, and y'all get all the rest.